right, so I'm here to fulfill a very important and meaningful mission. In these situations when you're asked to introduce someone, typically you say, "It is my honor, it is my privilege, it is my pleasure. It is deeply meaningful that Ephraim Margolin asked me to introduce him." But those words really don't capture my feelings for Ephraim, who has been such an influence in my life and my legal career. I decided it was appropriate to ask Ephraim what he wanted me to say about him, what I should emphasize. He said, "People have known me for 50 years. There is no need to say anything." Well, first of all, Ephraim, it is not 50 years, it is 63. It's 63, I believe, más o menos, since your admission to the California bar. 63 years of making a difference for those whose lives and liberties were in peril. I took another pass and I asked Ephraim, I wanted to make sure to highlight the contributions he has made to CACJ that are most important to him. He said, "I've written 5 pages about CACJ that I'm going to deliver. I don't need an introduction." My response was, "Ephraim, you sound like my mother. My mother is 102. She and Ephraim have known each other most of those 63 years, and they have in common a presence and a prominence in their respective fields which have overlapped." So I tried again, and I said, "Ephraim, what should I say?" He said, "Say I have 2 wonderful sons and 2 wonderful grandsons." I said, "You sound like my mother." So he was laughing loudly, but he wasn't budging. So, but what he emphasized to me is that he wanted this to be more personal than professional. So I'm going to try to adhere to that wish. Though I was CACJ's first student member, and that was thanks to Ephraim, I knew Ephraim would do far better in recounting CACJ's history, since he was literally there since the beginning, and I can do personal. Ephraim was my first Hebrew teacher. He was my first, and I should say my last, lawyer. He represented me and my fellow high school students when we were suspended for selling a yellow rag, basically, a yellow mimeographed newspaper called The Activist Opinion, which we mimeographed at the W.E.B. Du Bois Club on Fillmore Street in San Francisco. So I will offer a few more anecdotes along the way, but I want to begin with Shakespeare's line that what is past is prologue. And it's a concept that we as criminal defense lawyers know extremely well. Ephraim was born in Berlin and raised in Poland, which he and his mother fled for Tel Aviv in 1936. Ephraim did not come to the United States for more than 20 years, and during that time he became a member of the Irgun, which was a major underground organization that was fighting for the establishment of a Jewish state, graduated from Hebrew University in 1949, and then arrived in the United States to study law at Yale, getting a detour along the way. He was detained for 3 months at Ellis Island because of his membership in the Irgun. But after they released him, he went on to Yale, graduated, and then went back to clerk for the Israel Supreme Court. He finally made his way to California in 1962, where almost immediately Ephraim connected with the then very small ACLU of Northern California. This was a time in San Francisco, for those of you like me who I sort of barely remember, but maybe I remember sort of viscerally or vicariously through my parents. But this was just 2 years after the House on Un-American Activities Committee hearings in San Francisco. This was at a time when loyalty oaths were still prevalent. This was a time when the government and corporations still thought a communist was hiding under every bed. He became a volunteer lawyer in the ACLU. I think he handled at least a dozen cases, major cases for the ACLU. And I'm not sure if this was the beginning of the commitment, the promise that Ephraim made that he would devote at least a third of his practice to pro bono work, which he did throughout his career. Now, I don't know if Vicki Young, who is here, with whom he practiced many years, would agree that it was only a third. She might say that at times it felt closer to a half. But he was faithful to that promise. By 1964, he was full on with the ACLU. He was also teaching civil rights and civil liberties at UC Extension, and he made a side career as a law professor and as a college professor. So a decade before Ephraim, along with George Porter and about 60 other phenomenal lawyers, founded CJ, Ephraim successfully filed a petition for writ of prohibition in the Court of Appeal when a Fresno Superior Court refused to appoint the public defender because the defendant was out on bail. And in the minds of this judge, who apparently had a practice of refusing to appoint the public defender when anyone was out on bail, that defendant wasn't indigent. And Ephraim was victorious, and maybe that was one of the first connections between Ephraim and his long relationship with and support of and membership in the criminal defense community. But Ephraim, and I want to emphasize and stress these things because as much as we know what Ephraim has done for us in CACJ, there are so many other facets, so many other wonderful ways in which he has been a civil libertarian, in which he has fought against race discrimination, in which he has fought for our clients and for us as lawyers. He was involved in 1965 in the fight against Proposition 14, which was passed in order to derail efforts to end housing discrimination in California, a case that we won in the California Supreme Court and ultimately lost, as we have been living now with Proposition 14 for decades. We lost in the Supreme Court. In 1965, he represented 4 individuals who were demonstrating at San Francisco State on behalf of the First Amendment, 4 students. He represented all 4 of them, filing a 27-page pretrial motion, very Ephraim-esque, even in 1964. And in an interesting twist, the prosecution insisted on calling Ephraim, the defendant's lawyer, to testify at the trial. And I've often wondered whether that experience was, in a way, laid the groundwork for what later became Ephraim's expertise and specialization in representing lawyers who were in trouble. So a few more anecdotes. When I was 16 in the summer, I have to say the summer of 1967, so it's easy to figure out how old I am. But when I was 16 in the summer of 1967, Ephraim brought me into the inner sanctum of the ACLU, where the ACLU and the Legal Defense Fund were meeting with Tony Amsterdam. And he allowed me to sit at that table with Tony Amsterdam as the ACLU and the Legal Defense Fund mapped out the strategy for what would become Anderson and the road to the temporary but meaningful abolition of the death penalty in the United States. I found an article about this meeting in an ACLU newsletter. There was no mention of the 16-year-old who was smuggled into the meeting, but I did find the article. So, as you all know, Ephraim was one of CACJ's founding members. He was its first president. He founded the amicus committee, which he chaired until from 1973 to 1991. He authored some 1,500 briefs. And during the next 43 years of CACJ, Ephraim and John Phillipsborn, who's also here today, wrote most of CACJ's briefs. You can find mention of some of those briefs on the CACJ website, but I'm just going to tick off a few. Those of you in the room who are older will actually recognize the names of these cases. Before the United States Supreme Court, Goldberg in 1976, which was a pivotal case in rejecting the government's claim of work product privilege, where Jenks Act's discovery was at stake. Collender versus Lawson in '83 in front of the United States, declaring a statute making it a misdemeanor for a person stopped under a Terry stop to fail to provide credible identification, void for vagueness. In the California Supreme Court, Rockwell, another case ending the death penalty in 1976, albeit temporarily. Williams, which so many of you will remember, that opened the door to attorney-conducted voir dire, which was the bane. So much the bane of judges that we lost voir dire for a period of time in this state. Shirley in 1982, declaring inadmissible hypnotically induced testimony. And Brosnahan, which was our valiant attempt to keep Proposition 8 off the ballot. Multiple cases in the California Courts of Appeal, multiple cases in federal courts, in district court and federal appellate courts, dealing with attorneys who had been subpoenaed to disclose the source of their fees, to testify before grand juries, etc. Okay, I'm going to close in just a minute. I have a ridiculous 10 minutes, and I decided Ephraim deserves every one of those 10 minutes. I want to say a word about the intangible, which in many ways is Ephraim's most important contribution to CACJ. And if I were asked to sum up, and I've asked others, all of whom agree, to sum up his most significant contribution, it was that for many, many years, he was the conscience of CACJ. He was the font of wisdom. And I cannot tell you how many board meetings I attended, and others of you in this room attended, where we were, fighting in the most collegial possible way, of course, disagreeing, trying to work through incredibly difficult ethical dilemmas, deciding questions about initiatives that we were facing on the ballot or cases that were going to the California Supreme Court. And it was always Ephraim to whom we turned to try and figure out the heart of the matter, the soul of the issue, and what was fundamentally the morally in the best sense of what guides us as criminal defense lawyers, what was most true to who we are as defenders of the accused, defenders of the marginalized, what was most true to that devotion and that oath. And it was always Ephraim to whom we turned, and continued to turn until he packed his bags and went off to NACDL and spent another couple of decades being that font of wisdom on the national scene. So I want to leave you with a word of another personal story. When I was a brand new public defender in Solano County, I was in court one afternoon, waiting for my case to be called in front of a judge whose name I will never forget, Judge Raftery. And a pro per defendant came up for a status conference on, I don't even remember what he was charged with, misdemeanor, came up for a status conference, and the judge said to him, "Where are your jury instructions?" And the defendant said, was obviously utterly confused. "I don't have any jury instructions." "Well, your trial is in a week. Where are your jury instructions?" "You don't have jury instructions? I'm throwing you in jail until you prepare some jury instructions," and literally threw him in jail. It was late in the afternoon. I went back to my office. I had no frigging idea what to do, except I had to do something. I called Ephraim, and Ephraim dictated to me a petition for writ of habeas corpus, and which I walked up. In those days, we had misdemeanor and superior courts. I walked upstairs to Judge Sherwin, who's a superior court judge, handed to Judge Sherwin, and he was released. And that so embodies the kind of mentorship, the kind of friendship that Ephraim has given to me and so many in this room in your hour of need. Where do you turn? Where could we all turn? So, Ephraim has just finished his memoir. I understand will be published in the near future. I think the working title is From Freedom Fighter to Criminal Justice Warrior, and I would urge you all to give it a read. Ephraim, on behalf of CACJ, I'm going to come down to you. I'll take the mic with me and come down to you. Okay, you are the recipient of the first Ephraim, the first and only Ephraim Margolin CACJ Award, which says, "Your wisdom, passion, and dedication has shown us the way for the last 50 years and will continue to inspire and guide us for the next 50 years. We thank you." Kol hakavod.
Excuse me for speaking to you while seated. I am 97 years old, and sitting is probably the most becoming thing that I can do at this time. Dear CSCJ family, 50 years ago, we started with 60 invited California volunteer lawyers. We all met at San Francisco airport. Each one was given 1 single minute to tell us whether a new criminal defense organization is needed and whether it will be supported by private lawyers. Unanimously, we used our 1 minute to vote in the affirmative. When my turn came, I asked, "How does a fish get caught?" "By opening his mouth." I opened my mouth and I suggested how to organize CACJ. And I was elected the first president because I was less extreme than anybody else. At that time, no one could have imagined we will be still meeting and working 50 years later. CACJ became my love. Our mission was to give voice to criminal defense, to encourage friendships with each other, and to shake the foundations of the criminal law system in California. Our mission was to give voice to criminal defense and to shake the foundation of our criminal system. And within several months, as lawyers do, we had debated and solved dozens of issues. What to name the new organization? How to attract new members? How to reach and organize ourselves beyond the CACJ cities, big cities? Whom not to invite? What CACJ fees are appropriate? What priorities needed to be followed? And how do we turn from individual lawyers into a cohesive defense force, from private practice to the power of working together. Let me give you just one example. I am sorry, only one, because I don't want to take more time on that. In a small city in California, a lawyer wrote a letter to the grand jury giving them his opinions of what was appropriate. The district attorney recommended the lawyer be charged with contempt of court. We brought 180 declarations arguing that no contempt was intended, and we won. We helped many other criminal lawyers and many other issues of significance. We filed amicus briefs successfully. We argued in California legislature. We published the forum, and we published many other publications. We improved both the legal and the social cohesion with members of the defense bar, and we felt good about it. In my forthcoming memoirs, I am going to be publishing a book next week. I discussed the details of our last 50 years and the privilege of serving pro bono for a better California. I want to thank my CACJ colleagues who created the CACJ. They taught me the emotional and financial cost of serious criminal defense. We created a forum for a meaningful continuing education to better our own professional life and to work towards a fairer California. Looking forward to the next 50 years, CACJ will become even more important. Whichever way California moves, fairness and due process will remain a key to our success. This is our gift to ourselves and our gift to the state of California.